What's up, everybody? Welcome back into an episode of The Lawyer You Know. And boy, do we have a doozy for you today. Sarah Boone. Last time we left Sarah Boone, last time we talked about her, she was losing a lawyer. Well, guess what? She's not done. Somehow, some way, yet another lawyer has bounced from representing Sarah Boone. We'll talk about just the wild details of the timeline of that. Then we also talked a little bit about a motion for new trial for Lori Vallow, talked about what her arguments are, what we expected the outcome to be. It's been a couple months since the judge decided, but we haven't broken that down yet. We're going to break down the judge's decision to see if Lori Vallow is in fact going to get a new trial, or will she be on the appeal track similar to Sarah Boone. And lastly, we will talk about the brand new motion to change venue in Brian Walsh's case. Will that happen in Norfolk County, the same county they were able to pick a jury for Karen Reed's trial the second time? So how would it be possible that Brian Walsh would get a change of venue? What arguments is he making? And what do we expect the outcome to that to be? All that and more. Of course, we are going to answer your questions. Please do me a favor. Hit that like button. Make sure you're subscribed. Let's get to it. All right, so we're going to start out with Sarah Boone. We're also, as soon as the live is over, going to put these timestamps in, the chapter marks or whatever, so you can know which case, if you just want to jump to the one that you're interested in. We don't often do 3 in one video, but it just worked out to be able to do it this time. And Sarah Boone's case, in case you're not familiar, she was convicted of second-degree murder with her boyfriend slash fiance that she zipped in a suitcase while playing a game of hide and seek. She said it was not intentional. She didn't know that it was going to happen. She went upstairs, passed out, basically. Apparently and allegedly, the state offered her a plea deal of something much less than life in prison. She said no, went to trial and lost, and now she's looking at life in prison, and she's in the appellate process. But one of the more interesting things about the entire Sarah Boone saga and process is that she went through, I think, 14 or 15 different lawyers. Some she hired, some public defender, and even at one point representing herself, because the judge found that she had waived her right to counsel constructively, not openly with her own mouth that she wanted to waive her right to counsel like we've seen in Darrell Brooks and other cases, but instead by her actions and what she has done with her relationships and decisions with all these different lawyers. At one time, she represented herself. Then she had a lawyer who chose to come on and represent her at trial. He is gone, and now she is back to court-appointed attorneys in the appellate process. And where we left off is Mr. Adams, who was her appellate attorney, court-appointed, said, Judge, I know I used to say I want to do this work. I don't want to do this work anymore. I'm going to go do something else. That's where we're going to pick up on the judge's order, whether or not he would allow him to even withdraw from representing Sarah Boone. And Judge Kranick, our guy, said this cause having come before the court on the motion to withdraw and request for appointment of new appellate counsel, and the court having been fully advised in the premises, it is hereby ordered and adjudged that Joshua Adams is hereby allowed to withdraw from further representation of the defendant in the above style cause, and Rodrigo Caruso, Esquire, is hereby appointed to represent the defendant in this cause. Done and ordered in Orange County. This was on September 5th, a little less than a month ago. Okay, so sounds good. And we also know Mr. Adams asked for an extension. And let's take a look now at what the appellate court said about the extension, because obviously he's not going to be able to file Sarah Boone's appeal, so we need an extension of time. Well, what did the court say? The motion for extension of time is denied. Denied without prejudice. As appellant, meaning Sarah Boone, but really Adams, her attorney, has failed to certify that he has consulted with opposing counsel as required by Florida Rule of Appellate Procedure 9.300 sub A. I hereby certify the foregoing is a true copy of the original court order. So they denied it. So what does that mean? Is Sarah Boone screwed? Does this guy have to put his malpractice carrier on notice that he has screwed up her appeal and blown her appeal? No, it's just a technicality, but it's still a problem. It's still a big deal. He still needs to fix this so that Sarah Boone's rights can be protected. Because like we always say, we want to protect the rights of the worst of us so that we're protecting the rights of the best of us. And if Sarah Boone's rights don't matter, then your rights really don't matter, and my rights don't matter. So on September 16th, we have a follow-up order by the appellate court saying appellant's second motion for extension of time to file her initial brief docketed August 29th. So the very next day. And if you remember, he was let off the case on September 5th. So Adams was still on the case. So he fixed his error, which he found out about on August 28th, fixed it by August 29th. And that motion for extension of time is granted. The initial brief shall be served within 60 days from the date of this order. This order is on September 16th. No further extensions will be granted absent extenuating circumstances. Withdrawing counsel shall act diligently to secure successor counsel. So the appellate court is aware Mr. Adams is trying to get off the case. Judge Kranick has now allowed, prior to this order, but after Mr. Adams filed this second motion for extension of time, they're aware he's getting off. They're saying you better be able to get successor counsel on. So let's take a look at successor counsel. We know that successor counsel came onto the case September 5th, which I believe was a Friday, and he files his first motion on September 8th, the following Monday, I believe. You can fact check me on that. And what is his first motion while representing Sarah Boone? It is a motion to withdraw. Comes now Rodrigo M. Caruso and moves this court to allow him to withdraw from representation of the defendant, Sarah Boone, and as grounds, therefore, states the court appointed counsel to this case on September 5th, 2025. However, undersigned counsel has accepted a position within the office of the Attorney General's office of the statewide prosecutor effective September 12th, 2025. So this guy that was doing defense appeals now going to work for the statewide prosecutor, which is perfectly fine. And lawyers work on both sides all the time. But this is an indication of a problem to me that Sarah Boone is dealing with and that many criminal defendants in Florida and other states deal with. Lawyers that are court appointed, some public defenders, whatever it may be, if they don't like their job and they're changing jobs for whatever reason, and I'm all for somebody finding a job that they're happy in, they feel fulfilled in, a job they feel values them. So I'm not against people changing jobs. But when it comes to something as serious as this and your literal life is on the line, and we talk about the difference between people that have a lot of money and can hire a good private attorney versus court appointed or public defender attorneys, well, this is one of the big differences. This can happen in the private sector as well. Lawyers can just reject cases or can withdraw from cases for different reasons. But one of Sarah Boone's arguments is these lawyers don't really care about me, don't really care about my case. They don't call me back. And then when we find out, one lawyer says, I'm not doing this work anymore. The other one says, I'm starting a new job. You can start to understand where that might actually be true if they're on their way to whatever is next. So some legitimacy potentially to some of the arguments she's had in the past, although we're relating to them now with what she's dealing with and what she's going through. And by the way, we should all, and the victim's family, should want this appeal process to take place. Let's go. File your appeal, lose your appeal, let this be done, right? Because that's when justice is really final. Consequently, undersigned counsel is winding down counsel's criminal practice and has resigned from the court-appointed registry effective August 7, 2025. So how would he possibly be appointed? This is government, man. Sometimes it takes a long time for something to get uploaded to the system and for somebody to see it, and he's still there, and the judge just picks the next name in the queue. It's not the judge's fault. It's just how the system works sometimes. Because the defendant's case cannot reasonably be resolved prior to September 12th, I think that's true, 2025, undersigned counsel must withdraw from further representation pursuant to rules regulating the Florida Bar 417. Undersigned counsel has not previously filed a notice of appearance. Wherefore, counsel respectfully requests this honorable court to release counsel from further representation in this case and appoint new counsel for the defendant. So he literally didn't do one thing and now files this motion to withdraw. Let's see what Judge Kranick says. And by the way, he's filing this on the 8th. We know that appellate court order came down the 16th. So she has 60 days, which is about 2 months from the 16th, which would be November 16th, which is about a month and a half from now to file this appeal. So this order from Judge Kranick is on September 12th. So prior to the appellate court's order to extend the time for her to file her appellate brief. Order on counsel's motion to withdraw. This cause having been reviewed by the court upon the motion of Rodrigo Caruso, appointed counsel to withdraw from further representation of the above named defendant, that's Sarah Boone, and being fully advised of the premises therein, it is hereby order and adjudge that Rodrigo Caruso is hereby allowed to withdraw from further representation of the defendant in the above styled cause. And David Maldonado, bar number here, is hereby appointed to represent the defendant in this cause. Attorney Maldonado's contact information is as follows. It's further ordered that Rodrigo Caruso shall forward all discovery materials received in this matter to the newly appointed attorney. If no discovery has been received, Rodrigo Caruso shall immediately notify the newly appointed attorney. Ordered by Judge Kranig. So by September 12th, from September 5th to September 12th, she's gone through 3 attorneys, right? Adams out, Caruso in, Caruso out, Maldonado in. But what's important is her rights are at least being protected at this point, because prior to the appellate court's order, which they got that motion on the 29th, it took them till the 16th to give the order, which gave her kind of an extra 2 or 3 weeks that didn't toll her time that she had to file this appellate brief, which from my perspective is important when we're talking about protecting her rights. So Sarah Boone's rights, in my opinion, have been protected by the court moving expeditiously in this. And Caruso, I give him a lot of credit. I don't blame him. He already had a different job. He was already off the appointed list. He was just letting the court know, but he did it immediately. Some lawyers would take 2 or 3 weeks to even file that motion. They would still win, but it would be frustrating the process. So I give him a lot of credit for doing it immediately. And all of this was able to be turned around from September 5th to September 12th. And from the time that the second motion for extension of time was filed to when the order happened, which was on September 16th. So Maldonado, I haven't seen his notice of appearance. Hopefully he is in this case. Hopefully he has filed his notice of appearance, and it was all done before September 16th when that extension of time was granted. So he has 60 days to do this appeal, which he should be able to do. So that's what I'm hoping happens for Sarah Boone in her case. I truly can't believe the amount of attorneys that she's gone through. Truly can't believe it. I have seen cases where they've gone through a lot of attorneys. Never have I seen something like this. And I don't know if I ever will again. I literally don't know if I will ever see something like this again. So it's not often we can take a second and be like, this is a one-of-one case. It may feel like that to you guys that are just following cases on YouTube and maybe not quote unquote normal cases. But yes, Karen Reed was a one-of-one. Absolutely so was Sarah Boone. All right. Next, let's talk about Lori Vallow. So she filed this motion for new trial. We all assumed it would get denied. So there's no surprise there. Let's take a look. Nate Eaton posted this on Facebook. That's how we're going to read it. And this is the judge's order on her motion for new trial. First, the defendant argues that she suffered a due process violation. And if you can't read it, don't worry. I'm going to read everything here. By being made to proceed to trial when she was too sick to do so. And the court further violated her rights by seeking an objective determination of the extent of her illness. The defendant's motion for new trial raises new allegations regarding the extent of her illness that were not part of the record during the course of the trial. This issue was resolved during the trial, and the court has not been presented with any new reliable evidence indicating the defendant's illness negatively impacted her ability to proceed with trial. The record and observations of the defendant's physical appearance, questioning of the witnesses, and arguments to the court and jury all evidence the opposite, that she was able to proceed to trial. So sometimes you're damned if you do, you're damned if you don't. And it's like, hey, you did a good enough job, Lori Vallow, to where we can tell that that was not a problem for you. You were not too sick to proceed. The second point raised by the defendant is an allegation that the court lacked impartiality because of the court's evidentiary rulings. The defendant first argues that evidence of impartiality exists because the court sustained 2 hearsay objections from the defendant when the defendant attempted to cross-examine police officers about statements made by neighbors. The defendant's own motion establishes that these are the very definition of hearsay statement. It's like, that hurts when you represent yourself. By the way, in case you don't know who Lori Vallow is, she's somebody who was convicted of killing multiple members of her family, including her children and her ex-husband. This case was the one of her ex-husband. That was initially ruled self-defense, but she went to trial, represented herself this time after having public defenders in the Idaho case, where she also lost that one as well. When ruling on evidentiary issues, there is no rule or case law that requires the court to allow a response from the opposing side. The defendant argues in her motion that one of the statements was not offered for the truth of the matter asserted, but for the effect on the listener. The defendant never articulates what effect on the listener in the statement the statement would have had. The defendant also never articulates how, if that statement came into evidence and it was not actually offered for the truth of the matter asserted, which appears to be the only reason the defendant wanted the statement entered into evidence, it would have changed the outcome of the trial. High bar. She did not clear that high bar. Obviously not going to be a winning argument. The defendant then argues that she was unable to admit several exhibits and she could not effectively cross-examine witnesses regarding Melanie Boudreau. These are, again, basic evidentiary issues which were ruled on during trial. Just because the defendant does not agree with the court's rulings does not mean she is entitled to a new trial. The defendant never articulates how or why the court's rulings were wrong or how the rulings constitute a due process violation. The third area of arguments is titled, quote unquote, abuse of discretion. She argues, 1, that she was entitled to a Rule 13.5 hearing on aggravators. 2, the court did not release the jury from the admonition on the record. And 3, the court erred when allowing scientific evidence regarding GSR and DNA to be presented to the jury. And 4, she was denied the right to confront witnesses. Late check. The first 2 points in no way have anything to do with how the jury viewed the evidence or deliberated, therefore would not be the basis for a new trial. The court ruled on the 13.5 request, which is essentially moot, given the fact the defendant chose to stipulate to the aggravating factors rather than have the evidence to be determined by the jury. We knew this. It was kind of strange when she did waive it, but she definitely waived it. And then you waive these types of arguments post-trial. Again, she should know that. Obviously, she's not a lawyer. The defendant is correct that the jury was not released from the admonition on the record, but there is no rule or case law requiring the jury to be released from the admonition on the record. The court did not go back to the jury room and release the jurors immediately following the defendant's admission to the aggravating factors. Again, the defendant never articulates a reason why this would entitle her to a new trial. The defendant's argument about DNA and GSR, which is gunshot residue, evidence seems to be more a chain of custody or foundation argument rather than a substantive argument about the reliability of the evidence. The defendant's reply for the first time mentions the evidence being junk science, but she never presented any actual evidence or authority to establish the evidence was not reliable. Moreover, if there were questions as to its reliability, a competent and thorough cross-examination could have revealed those issues for the jury to consider. Although the state chose not to call the person who actually collected the evidence, the state satisfied the foundation requirements to admit the evidence through Detective Pillar, who was present during the collection of the evidence. The reply also alleges hearsay statements from Laychek were allowed into evidence, but does not state what those hearsay statements were. It is the court's recollection that no statements of Laychek were offered or admitted. That seems like something that would be easy to find. Finally, the court in no way precluded the defense from investigating this witness as the defense alleges, and in fact, the defendant could have subpoenaed and called this witness if she wanted to question this witness. But if you remember, there were subpoena issues. Did she do it right? Did she do it timely? Some people were objecting to the subpoenas. The defendant fails to establish any due process violation which would warrant a new trial in this matter. It is ordered denying Lori Vallow's motion for new trial. Once again, something that was exactly what we would expect, but another really good example of why representing yourself is a dumpster fire. It is a mistake. It is not just pre-trial where you might be able to get some evidence in. You might be able to subpoena some witnesses. You might be able to prep some witnesses to get some experts to do some depositions. If you represent yourself pre-trial, you're screwed. We saw what it looks like during trial, right? With Lori Vallow, with Daryl Brooks. We saw it here in Florida as well. And almost saw it with Sarah Boone. I can't remember that guy's name with the crazy hair that was like screaming during the opening statements. But it doesn't go well when you represent yourself at trial either. And this is an example that doesn't go well after trial, post-trial. These motions and the appeals do not go well when you represent yourself. All right, let's move on now to the last order of business here, which is probably going to be the one that takes the most time. And that is Brian Walsh's motion to change venue. So Brian Walsh's case is out of Norfolk County, Massachusetts. No surprise there. Another wild one coming out of there. Ronnie O'Neill. Yes. Thank you, Johnny. Ronnie O'Neill. Johnny Osprey, Ronnie O'Neill. Yeah, Daryl Brooks, I remember his name. I'll never forget his name. But Ronnie O'Neill was one from Florida that represented himself, and it did not go well for him either. So Brian Walshe is going to trial. It's supposed to go to trial October 20th. I think it is possible it goes to trial. It's also possible it gets continued, as is the case for most criminal cases. But he is accused of ending the life of his wife. There's a lot of evidence against him. There's some Google searches. There's some evidence at the house that maybe he did something to her body in the house and tried to make it disappear. And some things that he said, maybe that came back to be not true, that law enforcement is going to use against him. So there's plenty of evidence against him, but he is presumed innocent. It is also a lot of the same cast and characters from the Karen Read case, which is going to make the lives of the prosecutors a little bit more difficult than it would be if they had, good cops that don't have the baggage that some of these cops do. And when we look at it from that perspective, I think there can be some pros and some cons for Brian Walshe to have this case tried in Norfolk County. Because while, yes, he's going to talk about the publicity of his case in Norfolk County, there's also been a lot of publicity of that other case that happened in Norfolk County. And I think there's going to be a lot of jurors and potentially people that jurors know or that know the jurors, or they've heard reports or seen podcasts or represented anything or seen anything that has to do with the Karen Read case. They may just think this DA's office is corrupt. These cops are corrupt. We can't trust them. It's got to be beyond a reasonable doubt. We know how high of a burden that is. So it is possible Norfolk County is actually a good venue for Brian Walshe. And we are going to talk about kind of how it's possible Brian Walshe could get a change of venue and not be able to find a fair and impartial jury when Karen Read could do it. Not just once, but twice. In a much bigger case, nationwide, internationally, way more people following that case. I would think it would be way more difficult to find a jury in the Karen Read case, especially the second time, than Brian Walshe's case. And if you think that, you'd be correct. But there's one key element missing in the Karen Read case for us to be able to even perform this analysis. And that is Karen Read and her team did not request a change of venue. So if the defense doesn't request a change of venue, it's not just going to happen. There's no analysis to be done by the judge. The court doesn't have to make that decision. But Brian Walshe is asking the court to make that decision. Brian Walshe is saying, we need out of Norfolk County. What do you think? Tell me what you think in the chat. Do you think this is a good idea or bad idea for Brian Walshe? Because listen, no matter where you take this case, the evidence against him is the evidence against him. He has an uphill battle, no doubt about it, even with the presumption of innocence. Because we've heard a lot about the evidence, and there's a lot more motions filed. Let me know in the chat if you want me to go through a lot of those other motions in limine, things like that have a lot more details in them. And if you are interested in Brian Walshe's case, maybe I will do that for the podcast this week or something. Maybe I'll bring my dad on as well and kind of get his first look at the Brian Walshe case. But let me know in the chat if you think it's a good idea for him to try to get out of Norfolk County, because the bad facts are going to follow him wherever. And even if they don't move the case out of Norfolk County, but they just get jurors from outside of Norfolk County, to me, I'm not sure how that helps him. Because if the jurors in Norfolk County are side-eyeing the cops in Norfolk County and the DA's office there, that's a good thing for the defendant. They're going to scrutinize it. They're not going to just take what cops say as true. They might not even just take what the district attorney says as true. So, from my perspective, careful what you wish for, right? But let's take a look at what they are wishing for. Kitty Lucky said, I have a question. Doesn't peers mean that where you live? Not, or where you are. Not always. Not always. First off, you might not be there or live there, but whatever the action is could have happened there. So it's definitely not people that live where you live. And peers means basically a cross section of your society is what it's supposed to look like. Not people that look exactly like you or think exactly like you or live exactly where you live. All right, let's take a read here. Defendant's motion for a change of venue or alternative relief. Now comes the defendant, Brian Walshe, and moves that this court, pursuant to Massachusetts Rule of Criminal Procedure 37B1, grant the defendant a change of venue for trial outside of Norfolk County, or if a change of venue is not granted, to order that prospective jurors be selected from outside Norfolk County. So they either want the entire trial moved, or at the very least, from their jury pool being moved from outside of Norfolk County. And we're going to read the reasons why. But I want you to think about what I said and kind of what I mentioned off the top about what might actually be better about Norfolk County for Brian Walshe. And as we read, tell me in the chat if you get to a point where, yes, I'd want to move out of Norfolk County, or I think I would want to stay in Norfolk County if I was Brian Walshe. This motion is grounded in the belief that the defendant cannot obtain a fair and impartial trial within Norfolk County, and if forced to be tried in Norfolk County, cannot receive a fair trial if persons residing in Norfolk County are included as potential jurors in this matter. This request is based on one, voluminous pretrial publicity. If I'm the judge, I can't help myself but take Karen Reed's case into my analysis to say a bigger case with multiple trials, completely involving law enforcement, right? And the victim being law enforcement. If we were able to get a fair and impartial jury in that case that was even willing to render a not guilty verdict, I think we're going to be able to get one for Brian Walshe as well. And you're allowed to take that kind of analysis under advisement. And number two, the second reason they're arguing is the unique facts and circumstances of this case. Okay, let's be open to that argument. And three, the shocking allegations, I'll agree they are shocking, that have been reported in the media and the subject of podcasts, check, they're right there, since beginning on or around January 4th, 2023 and thereafter. So I do agree. People have been looking into this case. People have been talking about this case, and they are very shocking allegations and facts that have come out about this case. No denying that. As grounds, therefore, the defendant states the following. One, the defendant is charged in 3 indictments that in summary allege that he caused the death of his wife inside their home in Cohasset. Is it Cohasset? You guys will have to help me with the pronunciation there. On January 1st, 2023, dismembered her body inside the family home and thereafter scatter her remains in various locations, including trash dumpsters. Those are some of the shocking allegations. Cohasset is a town located in Norfolk County. Potential jurors in Norfolk County have been exposed to extensive and prejudicial publicity concerning this case through broadcast, print, and social media podcast. So what I will say is, if I'm the state, if I'm responding, yes, I agree. There has been extensive prejudicial publicity, but there's also been extensive, I don't know if you want to call it positive publicity, that Brian Walshe should get a fair trial. He deserves a fair trial. Can anybody get a fair trial in Norfolk County? He's gotten a lot more of that publicity than most criminal defendants get generally in cases like this. The extensive media coverage began on or around January 4th when Anna Walshe was reported missing and continued thereafter and continues to this day. The media coverage and repeated references to the allegations have continued thereafter for over 2.5 years. The publicity has included prejudicial facts and characterizations of the defendant and his past involvement with an unrelated case. We haven't talked a ton about his unrelated case. If it comes up in his trial, we'll talk more about it. Some people have talked about it. The generally bad guy rule, I'm sure, is going to apply to him. I know this is going to be the subject of some of the motions in limine, so we can dig into it more when we talk about those. Lauren said, maybe it's a tactic to delay. It's possible, but this isn't really one that would cause a delay usually. This is usually a pretty easy decision for a judge. Some judges, if they are going to kick the can down the road a little bit, is they would make the decision to say, well, let's try. Let's attempt to pick a fair and impartial jury. And if we can't, and we've tried day after day after day, maybe even week after week, and we can't find this jury that we need, then maybe we'll consider this motion to change venue. Maybe it'll be ripe at that point because we've tried and failed to pick a jury, which then obviously makes this argument in this motion a lot better for the defense. Okay. And by the way, the prejudicial facts, they exist in this case. They look bad, right? The way channels should talk about it is he is still presumed innocent. The state still has to prove these things. They are just allegations at this point. That is how they should all be couched and how everybody should be looking at the quote unquote facts of this case. The publicity has detailed both what is factually known, but in the great majority of the publicity has used speculation to effectively convict the defendant of the allegations without consideration to the presumption of innocence. Generally, I don't think we do that here, obviously, but generally, I would agree with this, that this is a cause of concern in this case, as it is in so many cases. In Koberger's case, even in Karen Reed's case, a lot of people were convicting her and saying, obviously, it was her. It probably was her. She probably did it. That's how most people talk about most criminal defendants, which is why we try so hard to guard against that, to change the narrative, to change the way people look at these cases. As the public, also as potential jurors, that's really important, to change the way we look at it so that this is not an automatic, obvious fact, as has been the case so often in our nation's history. When we talk about these kind of criminal cases, we convict people immediately. Trauger said, but I'm with Peter is saying, I actually think it'd be better for Walshe to stay in Norfolk County because the way things are right now, law enforcement is extra scrutinized. I tend to agree. Leanne, I think Walshe will be more interesting when it gets to appellate court. So much of the evidence should have been fruit of the poisonous tree. And yeah, we talked a lot about some of the stuff they tried to get suppressed. Some of it did get suppressed. Not enough, not what they really needed to get suppressed to have a really good chance at trial, in my opinion. But I definitely think there are going to be some real appellate arguments. I'm not sure how many of them are really going to be successful, right? But that's something I think we'll probably have to keep an eye on post-trial if he's convicted. If he's convicted. It is believed that the potential juror pool has been tainted, is biased, and cannot be impartial. And this is where a lot of judges would say, well, let's try. Let's attempt it first and see what we can find. It is expected that the publicity not only will continue, but intensify even more as the trial date in October, approximately 3 weeks away, approaches and will continue throughout the trial. I definitely agree with him there as well. The defendant was recently violently attacked and stabbed in the Norfolk County Sheriff's facility in Dedham, requiring hospitalization. There is no reason for the vicious attack. It may very well be the product of the depiction of the defendant portrayed in the media. So this is something could be true, could hold a lot of weight, could be really important, or could be seen as wild speculation by the judge. You even say there's no reason for it, there's no proof of it. For us to make a legal decision like changing the venue based on something you don't even know to be a fact is unlikely, probably not going to happen. In support hereof, the defendant has attached a memorandum of fact and law. In support of this motion, the defendant will file a supplemental pleading on or before the final pretrial conference that includes and incorporates examples of pretrial publicity that, due to its sheer volume, has taken more time than we anticipated to collect and organize the information. Accordingly, the defendant asserts that the prejudicial publicity will make it impossible, even with extensive voir dire, to find a fair and impartial jury. The defendant therefore moves, pursuant to Massachusetts Rule of Criminal Procedure 37B1, that states where there exists in the community where the prosecution is pending so great a prejudice against a defendant that he may not there obtain a fair and impartial trial. For a change of venue or alternative relief, the defendant sets forth both state case law and federal cases to support his request. Then he cites a couple cases. There can be no justice in a trial by jurors inflamed by passion, warped by prejudice, awed by violence, menaced by the virulence of public opinion, or manifestly biased by an influences operating either openly or insidiously to such an extent as to poison the judgment and prevent the freedom of fair action. Accordingly, the defendant moves for the relief requested herein based on the totality of the circumstances presently existing as argued herein and in the memorandum of law and fact and the above referenced supplemental pleading. Failure to grant the requested relief will result in a violation of the defendant's right to due process and a fair trial, to select a fair and impartial jury, and to have a jury free from bias and partiality as guaranteed by to him by the 14th Amendment to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights. So that is the main argument. And his argument about, the case law that he cited about guaranteeing a fair and impartial jury. And he is not going to get that in Norfolk, according to his attorneys. And saying, if you don't do this, judge, you're creating an appellate issue. Basically is what that last paragraph is about. People asking what case we're talking about. We're talking about Brian Walsh's case, which is supposed to go to trial on October 20th. His lawyers have filed a change of venue. So usually when you're adamant and you say, oh, he's not going to be able to find a fair and impartial jury, you need to provide the news clippings or podcasts or whatever people are saying, how many people are watching, is the demographic in Norfolk County. We got a really good look at this in the Brian Koberger case where they actually won their change of venue, which I think ended up hurting them. But we were able to see what a good one looks like. They're going to need a lot more than what they've presented here. And what they presented here is kind of like closer to the Adelson change of venue, who there were some lawyers in Tallahassee who were like, hey, pay attention to that. I think they might get that. I was like, I don't think so. I don't think they're going to get it. And I really don't think Brian Walshe is going to win this one either. I think the judge may give him something like, let's at least try to pick a jury, see how it goes, and then we can go from there. Allie said, have you and or Big George read To Kill a Mockingbird? It's a good one. So, guys, this is probably true of many people of my generation. I don't know if my dad has. He probably has. I know my sister, who's an English teacher, has read it and loves it. I have never read it, but I have seen the movie, which I know does no justice. My wife is also a big time reader. And every time we watch a movie, whether it's like Harry Potter or what is the one Mockingjay, what is that called? Whatever that's one it's called, where Hunger Games, whether it's Hunger Games or Harry Potter, she's always like, the book is so much better. And now my daughter has been reading some of those books and she says the same thing. She's like, the book's so much better, but she wants to always watch the movie after the book. So I'll always watch the movie with her after the book. But I have read the movie. I've read the movie. I've watched the movie. I have never read the book, but maybe I should. Larry said, Sarah Boone goes through lawyers like toilet paper. Yeah, I mean, none of these are her fault, right? None of the recent ones with the appellate lawyers are her fault. Trogger said, I've read it and watched the movie and love it. And I'm not a book person. How come you didn't have to read that one in high school, Peter? I thought we all had to read that one. So I also in high school may or may not have been somebody that was introduced to Cliff's Notes early on and was able to get by just fine with Cliff's Notes instead of reading the entire. I honestly can't remember reading a single book front to back in school my entire time in school, outside of law school. I feel like I read every single textbook I had beginning to end. I read more pages in law school than probably most kids read their entire life. None of it fun. None of it did I like, but yeah, I know. So I see, and this is going to be so Audible. So I do listen to books. I listen to books on 10 times speed. I listen to 4-Hour Work Week and entrepreneurship books all the time. Besides my Bible, I do read that every single day. I've read that cover to cover. I've read every page of the Bible. But as far as like, especially fiction, I've never been able to get into fiction. I do like nonfiction a lot more. I do like listening to it a lot more than I don't. I listen to a lot of podcasts and read a lot of articles. So a lot of times that is how I get the information. To Kill a Mockingbird said, Sabertooth said To Kill a Mockingbird was required reading in my high school. Probably wasn't mine too, if I'm being completely honest. But Kathy said, I find that surprising. I know. Most people assume I'm big into reading, like reading. Just am not. I don't know why. I feel like it's my brain, like it's hard to just sit there and read, because usually when I'm listening to a book or a podcast, I'm also doing something else. I'm almost always doing multiple things at once. Thank you, Sabertooth, for gifting 10 Lawyer No memberships, and welcome to all of the new members. Trogger said, I was just going to say, Peter is a Cliff's Notes guy. I just asked my husband if they still have those these days because I'm having trouble helping my son with his book reading. Yeah, it's a wild world. Helping kids in school is tough. We're in the thick of it right now with a middle schooler and an almost middle schooler. Audiobooks count? Good. Thank you, Book Dragon. With a name like Book Dragon, I feel like we have to trust you. Audiobooks count. And nonfiction is totally fine. Thank you so much. I feel very accepted in this chat today. Thank you. Yes, I have the Libby app. I have Audible. Is that the one through Amazon? I have that as well. I have a couple of them. All right. That's it. Little hodgepodge of an episode today because you guys had kind of sent me some stuff on Boone earlier, on Lori Vallow earlier, and then some of the Walshe stuff now. So I figured it was good time to catch up on all of those cases. Make sure you continue to send me whatever it is you're reading or listening to or seeing. Make sure you guys are all subscribed. Sometimes it unsubscribes you from YouTube, and I want you to come back, hang out, get in the chat, talk through these cases with us. I think I'm going to look at the rest of the Brian Walshe motions tomorrow or this weekend and maybe pull my dad in, like I said, and go through those as we are getting prepared to follow that trial in about 2 or 3 weeks when that one begins. Mary said, Peter, have you checked out Lexis AI? It's cool, but worried about my career. Yes, we have Lexis AI. It is not taking anybody's career from my office yet. Right. We'll see what it does. We'll see. I don't think we're ever going to completely get rid of people. On our members only kind of 4-person Zoom, we talked a lot about AI and what I kind of think on AI, which is probably different than a lot of people do think, but we'll save that for another episode. I appreciate you guys all coming in and joining me here today for this video. Hit the like button on the way out, if you don't mind. That's all we got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.